Good afternoon, everybody. So we're going to start. This year is going to be the shortest version of the Managing the Risk session you have seen in the last 5 years. We have a few logistical problems in that we have few friends who have to catch a flight, so we're going to move on. There will be a special feature to this session, which is questions are allowed, but this year, and it's going to be undisputable, Lauro and myself decide that the question which has been asked is stupid, there is going to be a penalty. So be careful on the questions you ask. Lauro.
Can I ask a question?
No. So, good afternoon, everybody. The time is really running short, so I'll start introducing the first of our very distinguished speaker. This is Andrew Taylor, solicitor in England and Wales, graduated at Oxford University. He has been chairing Richard Butler from 2000 to 2005, and is today, partner at Reed Smith, and is talking to us about a very, very interesting topic. It's the Marine Insurance Act. The previous one was 1906. Now, there is a new Marine Insurance Act, which is 2015, will be effective as of 12th of August 2016. So there will be plenty of forum, I feel, from now until the date and even afterwards. But of course, we have the privilege to listen from Andrew Taylor some comments about the new MIA. Please.
Since this is not a very serious session, since Mitropoulos is now sitting here, I want to say that I'm very happy that Andrew, after the 6th edition of Shipping and Law, is here, and he is not allowed to speak. He will not come for the next 6 editions, at least. Then, after having said this, I know that he studied at Oxford. This is the reason why the letter applied to Cambridge, but she ended to be in St. Andrews. Unfortunately, the Holy Ghost has brought her in the end to Oxford, which is something I'm very worried about. But I'm also very happy that an old friend is joining this bunch of friends as Andrew.
Thank you very much indeed, Francesca, and good afternoon, everyone. As Mauro said, the Insurance Act 2015, and hold on, let me just check my slides are working. They should be on the screen, I hope they are. Yes, here we go. Move to the first one, thank you very much. So this act will become part of English law on the 12th of August 2016. So there's plenty of time to prepare for it. And as was hinted by Mauro, the idea was to bring English law, which is essentially based on the 1906 Act, up to date. And there was also a feeling that the act, the system, the law in England was a little bit favourable towards insurers. And this is manifested in two particular ways. First of all, with warranties, and secondly, with the pre-contractual obligation to give full disclosure. And as I'm sure many of you know, the consequences of breaches of those two obligations gives insurers very wide powers to avoid the policy and be discharged from liability under the policy, even if the breaches by the insured seem to be relatively modest. But it is fair to say that the Act is focused on consumers, as indeed many legal acts nowadays are. And it is in that context that you should understand this Act. It is principally designed to protect the consumers, but non-consumers have full powers to avoid the effect of the Act. So if I just could move on. So, what does the Act now do? First of all, let's look at the question of disclosure. This has now been changed into a new duty, which I hope you can see on the slides, a new duty to give a fair presentation of the risk. And as you can see, that means, again, disclosing every material fact, and that is just the same as the existing law. So no change. It's just a reformulation of an existing concept. And it goes on to say, this is the second way in which an insured can satisfy his obligation, if he discloses sufficient information to put a prudent insurer on notice that he needs to make further inquiries. That is new, and I shall come back to that again in a minute. Now, as I said, the point about the old law was a breach of this obligation to give disclosure, or now fair presentation, was that the underwriter could avoid the policy. What is new about this Act is that the remedies for failing to give a fair presentation are new. And there's a distinction between deliberate and reckless non-disclosures, which result in avoidance, or what are described as innocent or negligent ones. So if there's an innocent or negligent non-disclosure, the new Act effectively reorganizes the arrangement between the insured and the insurer and asks itself the question, what would have happened had there been full disclosure? And there are various options, various possibilities, and one possibility may simply be that more premium would have been paid, and had more premium been payable, then the underwriter can reduce the amount of the claim he pays in proportion. The other point to note about this fair presentation obligation is it refers to things which are unknown or ought to be known. Again, this is a familiar expression, but in the new Act, that is explained by saying that an insured is deemed to know what he would reasonably have revealed by a reasonable inquiry. And therefore, this perhaps puts a little bit more burden on an insured to be careful to make sure he knows everything which is within the realms of knowledge of his company and to make sure that it is revealed. And similarly, the insurer is now deemed to know everything which is known to his company. So insurers now must be more careful about ensuring there is a free flow of information, relevant information, from the claims handlers to the underwriters. Now let's look at warranties. Now again, under the current legal regime, any breach of warranty entitles the insurer to be discharged from liability, even if that warranty is irrelevant to the circumstances of the casualty or the event, and it cannot be remedied. So once you're in breach of warranty, that is it. What the new Act does is provide that a breach of warranty gives rise to a suspension of the cover rather than a termination of the cover. That I don't think is particularly controversial. And I've put here a little diagram of a yacht just to illustrate this. So if you are an owner of a yacht and you've insured your yacht for pleasure purposes only, and you take paying customers on board for a fishing trip, then your cover would be suspended until that event had come to an end. Now let's look at another typical problem with an insurance contract. These are terms which tend to reduce the effect of certain types of possible events. So it reduces loss of a particular kind, loss at a particular time, or loss at a particular location. For example, trading warranties would be a typical example. If insofar as the underwriter wishes to avoid liability or reduces liability during such periods, then that is going to be no longer possible under the Act in circumstances where the insured can prove that the relevant breach was unconnected with the loss that has been incurred, the so-called irrelevant warranty issue. And then back to my examples, which you see I've put a padlock on the screen. So if, for example, you have warranted that your house will be locked, then if your house is burnt down by a fire, underwriters cannot avoid the policy because there was no connection between the two events. I'm keeping it very brief so we can keep in touch. There will be time for questions. Now, here is something, basis of contract, here is something which the Act refuses to allow even non-consumers to contract out of. So from August 2016, this will be the law and cannot be changed by contract. These are provisions frequently seen in policies which state that any information or particulars provided by the insured at the time he enters into the policy will be treated as though they are warranties in the policy, so that any breach of that warranty or that term would result in avoidance. Those provisions, as I say, are now strictly forbidden. The Act had only been passed and waiting for enforcement for a few months before there's been an amendment. So in the Enterprise Bill, which is only published a month ago, there is to be a fresh provision which purports to place an obligation on insurers to pay claims within a reasonable time. This is controversial, and this is going to be another provision which cannot be contracted out of by insurers in circumstances where a non-payment of a claim is reckless or deliberate. And I want to move on to the final subject, which is contracting out. Because as I've emphasized at the beginning, this is, if you like, a consumer-driven piece of legislation and accepts the possibility that non-consumer insurers, commercial insureds will wish, and insurers will wish to contract out. And broadly speaking, that is permitted. Now, where have we got to with contracting out? So far as the London market is concerned, this is the whole market, the war market, this is presently under consideration. They haven't decided whether they are going to contract out of the Act, and if so, to which extent. The international group of P&I clubs, however, have already entered into this debate and are recommending to clubs that, first of all, they accept the duty of fair presentation, but contract out of the remedy, so that if you fail to give a fair presentation, avoidance will still be the remedy. And so far as concerns warranties and other terms, the recommendation is that clubs should contract out of those provisions, so that going forward, any breach of warranty or condition will have exactly the same consequences as are presently contained in the rules of the clubs. And that, I hope, did not last more than 10 minutes. That is all I have to say. Thank you very much indeed.
Thank you, Andrew. It was great, very effective, and really within the 10 minutes, I would say that you touch, among the various points, one of a very interesting subject, which of course is the different interpretation of warranty in respect of the previous MIA, and that is something which can solve also one of the existing problems for many of the Italian ship owners, that they have Italian policy subject to Italian law with English conditions. And then, we know that up to now, the interpretation according to the Italian law, was more similar to the one of the new Marine Insurance Act. So from this point of view, after 2016, that is going to be easier, if you like, for all of us, underwriters and clients, to see whether a claim falls or does not fall within the policy condition. Now, I hand the floor on to Federico for the presentation of the next speaker.